Mr. President, members of the court, good afternoon. It is, as always, an honor for me to appear before you. This time, it is both a special privilege and a grave responsibility to represent the Gambia in its effort to prevent further acts of genocide against the Rohingya people in Myanmar. These horrific acts committed by the state of Myanmar have been comprehensively documented by the United Nations fact-finding mission, the UN High Commissioner for Human Rights, the UN Special Rapporteur on the situation of human rights in Myanmar, the UN Special Advisor on the prevention of genocide, and numerous independent human rights organizations and experts. Based on these highly credible reports, it is blindingly obvious that there is an urgent need for provisional measures to prevent irreparable harm to the rights at issue in this dispute. The requirements of urgency and irreparable harm are more than fully satisfied here. This case for provisional measures is among the most compelling that have ever been heard in this great hall of justice. As the court has emphasized in its prior rulings on provisional measures, quote, the condition of urgency is met when the acts susceptible of causing irreparable prejudice can occur at any moment before the court makes a final decision on the case. That is precisely the situation here. It is exactly what the UN fact-finding mission concluded in its report of 16 September 2019, which you will find at tab 2, page 3 of your judge's folders. The mission concludes, based on its findings, that grave violations against the Rohingya continue, and that there is a real and significant danger of the situation deteriorating further. The mission also has reasonable grounds to conclude that the evidence that infers genocidal intent on the part of the state against the Rohingya, identified in its last report, has strengthened that there is a serious risk that genocidal actions may occur or recur, and that Myanmar is failing in its obligation to prevent genocide, to investigate genocide, and to enact effective legislation criminalizing and punishing genocide. These conclusions, as you have heard, are based on thorough and meticulous investigations carried out over a 2-year period and resulting in voluminous reports totaling over 700 pages. Even more recently, on 26 November 2019, the United Nations Special Rapporteur on the human rights situation in Myanmar wrote, as you can see at tab 14, the Rohingya still living in Rakhine State continue to be denied their most basic rights and are confined to either closely guarded internment camps or remote villages. The system of oppression remains unchanged, and they are at real risk of recurring genocide. Mr. President, the evidence that is now before you is several orders of magnitude greater and even more compelling than the evidence submitted by Bosnia in 1993. which the court found sufficient to determine that, quote, there is a grave risk of acts of genocide being committed. On that basis, the court indicated provisional measures to ensure that the parties, quote, do all in their power to prevent the commission of any such acts in the future. Since 1993, the court has repeatedly found the requirements of urgency and irreparable harm to be met in situations where the threats to human life or to other fundamental human rights short of life itself were considered serious. In Democratic Republic of Congo v. Uganda, the court ordered provisional measures based on its finding, quote, that persons, assets, and resources present on the territory of the Congo, particularly in the area of conflict, remain extremely vulnerable, and that there is a serious risk that the rights at issue in the case may suffer irreparable prejudice. In the certain activities case, the court ordered provisional measures prohibiting Nicaragua from sending its personnel into disputed territory, in part because, quote, the situation gives rise to a real and present risk of incidents liable to cause irremediable harm in the form of bodily injury or death. In Ukraine v. Russia, the court ordered provisional measures on the ground that, quote, Crimean Tatars and ethnic Ukrainians in Crimea appear to remain vulnerable because, quote, certain rights in question in these proceedings, in particular, political, civil, economic, social, and cultural rights, are of such a nature that prejudice to them is capable of causing irreparable harm. Here, the Rohingya are not only deprived of their political, social, and cultural rights, they are threatened with massive loss of life itself. And striking at the heart of these proceedings, with loss of their very existence as a group. In Qatar, the United Arab Emirates, the court ordered provisional measures to protect the rights of Qataris living in the UAE. The court found that, quote, individuals forced to leave their own place of residence without the possibility of return could, depending on the circumstances, be subject to serious risk of irreparable prejudice. At the time the court made this finding, according to the UN fact-finding mission, the Rohingya in Myanmar were suffering an even worse fate. They too were forced to leave their own place of residence without the possibility of return. But in Myanmar, the UN fact-finding mission found that this was because the army, the Tat Madar, deliberately burned thousands of their homes to the ground, often with family members forced to remain inside, and went on to slaughter masses of men, women, and especially children, with the intention of destroying the Rohingya as a group. Since then, the threat of genocide has not abated, but grown even worse, as the UN fact-finding mission concluded in its report of 16 September 2019. Evidence of Myanmar's genocidal intent toward the Rohingya has actually, quote, strengthened in the past year. In the case of Qataris living in the UAE, the court was of the view that, quote, a prejudice can be considered as irreparable when individuals are subject to temporary or potentially ongoing separation from their families. and suffer from psychological distress, when students are prevented from taking their exams due to enforced absence, or when the persons concerned are impeded from being able to physically appear in any proceedings or to challenge any measure they find discriminatory. Mr. President, the Gambia agrees that these are very important human and civil rights, whose interim protection by the court is justified where the facts show that their enjoyment is threatened irreparably. If that is so, then how much greater is the justification for provisional measures here? This case is about the commission of genocide, the most heinous of all crimes. The evidence before you makes clear that provisional measures are urgently needed to protect a group that is at serious risk of suffering further genocidal acts, which independent observers have warned are capable of recurring at any time, including another clearance operation, which is Myanmar's own Orwellian term for the targeted killing of Rohingyas, burning of their homes and villages, and especially brutal and depraved acts of sexual violence against women and girls, the very kinds of atrocities the Genocide Convention was intended to prevent. Mr. President, if provisional measures were justified in all of these cases, they must be justified in this one. More recently, in the alleged violations of the Treaty of Amity case, the court, using language that is especially pertinent here, found that, quote, a prejudice can be considered as irreparable when the persons concerned are exposed to danger to health and life. The court ordered provisional measures, notwithstanding the assurances given by the United States that it would use its best endeavors to ensure that humanitarian or safety of flight-related concerns receive full and expedited consideration. The court explained, quote, while appreciating these assurances, the court considers nonetheless that insofar as they are limited to an expression of best endeavors and to cooperation between departments and other decision-making agencies, the said assurances are not adequate to address fully the humanitarian and safety concerns raised by the applicant. Therefore, the court is of the view that there remains a risk that the measures adopted by the United States may entail irreparable consequences. Without question, if humanitarian and safety concerns merited provisional measures to protect the people of Iran against an economic and commercial embargo, they are absolutely indispensable here, where the Rohingya face every single day the risk that they and their children will be killed or raped en masse, pursuant to what independent expert investigators have found to be Myanmar's ongoing and strengthened genocidal intent. In the case between Iran and the United States, the court found that the assurances of the respondent state could not serve as a substitute for provisional measures. Even less can they substitute for provisional measures in this case. Myanmar, from its highest official levels, has been giving empty assurances to the United Nations repeatedly, since even before the first clearance operation in 2016, and it continues to do so. It backs them up with phony investigations, finding no wrongdoing whatsoever. A complete whitewash, in the words of a former United States ambassador, a total lack of accountability, according to the UN fact-finding mission. The UN Special Rapporteur on the human rights situation in Myanmar recently explained why Myanmar's assurances cannot be relied upon in a document you will find at tab 14. Those responsible for these violations enjoy impunity, which perpetuates the devastating cycle of abuse. This is because the emboldened military leadership retains a firm grip on politics and the economy, while the government has so far proved unwilling or unable to make any significant move against them. Under present conditions, the Special Rapporteur concluded Myanmar is simply, quote, incapable of delivering accountability. Incapable of delivering accountability. The Special Rapporteur ended with a warning that the military, backed by Aung San Suu Kyi, has responded with defiance and with the immediate threat of further atrocities present, more must urgently be done to prevent further tragedy. Mr. President, as if to prove the Special Rapporteur's point, soon after the Gambia's application was filed with the court, billboards were posted across Myanmar like this one, which you will find at tab 20. The three smiling Tatmadaw generals behind the agent are Myanmar's Minister of Border Affairs, Minister of Defense, and Minister of Home Affairs. This shows, in fact, it can only have been intended to show that they are all in it together, and that Myanmar has absolutely no intention of holding its emboldened military leadership accountable. Mr. President, in these circumstances, for the court not to order provisional measures would be to completely ignore the imminent risk of death and destruction that the Rohingya face today and every day during the pendency of these proceedings. And it would be a complete break with the long and distinguished line of jurisprudence that the court itself has firmly established and very recently confirmed. There is law, and there is also morality. They are not opposed. In its advisory opinion on reservations to the Genocide Convention, the court explained, the convention was manifestly adopted for a purely humanitarian and civilizing purpose. It is indeed difficult to imagine a convention that might have this dual character to a greater degree, since its object, on the one hand, is to safeguard the very existence of certain human groups, and on the other, to confirm and endorse the most elementary principles of morality. What happens when international institutions lack the will to uphold these elementary moral and legal principles? Lieutenant General Romeo Dallaire, commander of the UN peacekeepers in Rwanda in 1994, offered sobering testimony, which you will find in your judges' folders at tab 21. Almost 50 years to the day that my father and father-in-law helped to liberate Europe, when the extermination camps were uncovered, and when in one voice humanity said, "Never again," we once again sat back and permitted this unspeakable horror to occur. We could not find the political will nor the resources to stop it. There is no uncertainty about who we are. According to the report of the Independent Inquiry into the Actions of the United Nations during the 1994 genocide in Rwanda, quote, "The United Nations failed the people of Rwanda during the genocide in 1994. It is a failure for which the United Nations as an organization, but also its member states, should have apologized more clearly, more frankly, and much earlier." Mr. President, members of the court, apologies are not enough. They always come too late, when there is already something to apologize for. The failure to act and the resulting catastrophe that might have been prevented. And as history has shown, when the international community fails to act, it only invites further catastrophes. In Lieutenant General Dallaire's distressingly prophetic words, quote, "The genocide in Rwanda was a failure of humanity that could easily happen again." Mr. President, tragically, it has happened again in Myanmar, and still, the world has not yet found the will or the means to stop it. So say the independent fact-finding reports of highly credible investigators acting under the mandate of the United Nations. So say the most respected international experts on genocide, including those of the United States Holocaust Memorial Museum, who have written, "Shocking in scale, the mass atrocities against the Rohingya were predictable and preventable. Following decades of escalating persecution, including the revocation of citizenship and restrictions on basic freedoms, the Burmese government, as well as the international community, failed to respond to the early warning signs and prevent the genocide." Mr. President, genocide in Myanmar is happening still. Of course, Myanmar denies this, as have all the perpetrators of genocide throughout history. But the UN fact-finding mission, the UN Special Rapporteur, and other independent experts and observers have heard all of Myanmar's excuses and explanations and found them unconvincing and even cynical, and refuted them one by one in their detailed reports. The Gambia has come to the International Court of Justice in the face of an insufficient response by the international community, because, as its agent so eloquently put it, it has faith in this court to uphold the Genocide Convention and the humanitarian and civilizing purposes it reflects. The time to prevent further genocide is now, because nothing less will save the Rohingya from their ultimate destruction as a group. In these proceedings, the Gambia asks you to order Myanmar to do what it is already obligated to do under the Genocide Convention, but has refused to do and cannot be counted upon to do without the court's intervention. The court spelled out these obligations in its judgment in the Bosnia genocide case, where it made clear that the obligation to prevent genocide does not only come into being when perpetration of genocide commences. That, the court said, would be absurd, since the whole point of the obligation is to prevent or attempt to prevent the occurrence of the act. In fact, the state's obligation to prevent and the corresponding duty to act arise at the instant that the state learns of, or should normally have learned of, the existence of a serious risk that genocide will be committed. From that moment onwards, if the state has available to it a deterrent effect on those suspected of preparing genocide or reasonably suspected of harboring specific intent, it is under a duty to make use of these means. Mr. President, the Gambia asks you to order provisional measures that require Myanmar to fulfill this obligation by refraining from any further acts of genocide and by using every means at its disposal to prevent further acts of genocide against the Rohingya people. In 2 words, Mr. President, the Gambia asks you to say to Myanmar, never again, and to say it in the clearest of terms and with all the legal and moral force that this highest of all international judicial authorities commands. The UN fact-finding mission, at the conclusion of its report of 16 September 2019, made a series of recommendations to the United Nations and the international community on actions that must be taken to prevent further genocidal acts against the Rohingya people. Among them is this one, at tab 2, page 22. Encourage and support states party to the Genocide Convention to bring a case to the International Court of Justice against Myanmar for breaches of its obligations under the Genocide Convention. The Gambia has heeded that call. On its own behalf, as a state party to the Genocide Convention, on behalf of the 57 member states of the Organization for Islamic Cooperation, which have fully endorsed and encouraged this case, and most especially on behalf of the Rohingya people, whose hopes for survival as a group in Myanmar now rest with you. On behalf of all, Mr. President, the Gambia calls on this honorable court, humbly and respectfully, to indicate the particular provisional measures that are urgently required in these exigent circumstances, and that my distinguished colleague, Professor Sands, will describe for you. Mr. President, members of the court, this concludes my presentation. I thank you, as always, for your kind courtesy and patient attention, and I ask that you call Professor Sands to the podium.